Okay, you guys, this is the final video of the Circular 230. So he's just going through the final information on this. After you have watched the final video of the 230, let me know, email me and say, hey, I've completed it, so I can send you over the test. The test is about 20 questions, and it's just going to be basic. Well, it's going to go through what the information that you've just watched. So just be aware of the responsibilities of the tax preparers and what are the regulations the IRS requires you to follow and the penalties for not following them. So I'm going to let him finish those last 30 minutes off, and then we're going to get right into the next section, with the personal income taxes. This is just to show you how the personal income taxes look and how you're going to put it into the computer system. After I upload those 3 hours, I'm going to go back and finish the 6 hours on where we initially started from. So it's a lot. The main reason why I didn't finish those videos is because a lot of a lot of business taxes. We need to get into these personal taxes. So that's why I'm uploading it this way.
Okay, so moving on. We're on slide 35. Subpart B, section 10.28, the return of the client's records. In general, the practitioner must, at the request of a client, promptly return any and all records of the client that are necessary for the client to comply with their federal tax obligations. For purposes of this section, records of the client include documents, whether they're written or electronic, provided to the practitioner. So if they've provided to you a QuickBooks file, you have to promptly return that record to them. You cannot keep that record and withhold it on them. Or if they're obtained by you in the course of the representation of the client that pre-existed the retention of you by the client. This is very, very important. Now, this is not what I defined earlier as your work papers. Your work papers you can keep. This is just the client's records. My recommendation to our clients is keep separate files. Label them in your office. So this came from the client. This is mine. This is theirs. Keep separate QuickBooks files. When we take a copy, it's always labeled as an accountant's copy. And we save it as an accountant's copy. And if we end up overwriting their data, well, they get our copy, which is usually better anyway. But at least we've kept our copy of what our source data was. It's very, very important when it comes to taxes for the businesses that you represent and the returns that you're filing for the businesses, especially as we talked about earlier with the example of my California employer and that particular account. In fact, that one went so far as that accountant, there was a dispute between the accountant and the client. And the accountant in that case wanted to hold all of their work product. And what they ended up claiming was that, look, you gave me time tickets. You gave me employees' names. You gave me wages. I'm the one that put those into a spreadsheet. I'm the one that submitted those 941s to the state, to the federal government. That's my problem. I don't have to give those to you. If you wanted to figure them out, you have to do them now because I prepared those. But that account had to return all the source data back to the client, whether they were happy with that client or not happy. So it's really, really important. Because here's what happens if they don't. If they don't return that source data back to the client has no way of knowing what was filed. There's a way to get what was filed. It's called a transcript request. So if you run into this problem of the return of the records, make a transcript request. There's a form for it. I can't remember the identifying numbers right now. There's a form for everything with the IRS. But there's a transcript request form. It's very good. You mark the form as to what tax year you want, what tax form you want, and you'll be able to get all of those 941s that were filed on behalf of your client. That's why they have this section. You are required as a return preparer to give them back their records. If they want to see the final filed document, and you didn't give them a copy of that document, whether it's because they didn't sign it, they didn't prepare it, they didn't pay, whatever it was, they can get a copy by filing that transcript request. So keep that in mind if you ever run across that problem. Let's take a look at section 10.29, and I'm on slide 36, and it's conflicting interests. We take a look at the first section. A, except as provided by paragraph B of this section, a practitioner shall not represent a client before the Internal Revenue Service if the representation involves a conflict of interest. Okay, what's a conflict of interest? I studied this in law school. We live by this rule. We try to live by this rule as attorneys. And here's what it is. The representation of a client that will be directly adverse to another client. So please know that if you're representing a partnership and you're preparing returns for a partnership, if their interests are aligned, you can represent both of those parties before the IRS. In other words, you can do both of their tax returns. You can do the tax return for the partnership, and if the individuals want to come to you, you can do the individual tax return. Now, what you cannot do, if there is an adverse interest to them, depending upon how you do that partnership return, if the partnership return is being done one way, and you know they've agreed to split profits and losses different than 50-50, but one of the partners is wanting you to do something different on his personal tax return, now you have a conflict of interest because you're reporting the partnership return as 50-50. And now one of the individuals is telling you, I don't want you to report my profits as 50-50. I only want to report 40 of them. He should be reporting 60. He is a 60% partner, not 50-50. Now you potentially have created a conflict of interest because of your representation of what? The partnership. So when it's one client and it's directly adverse to the other, you have a problem. There is a significant, or if there is a significant risk that the representation of one or more clients will be materially limited by that practitioner's responsibilities to another client. Same scenario. If you are being limited by your representation of the entity, you've prepared the 1065, and it's limited now to what you can do to the individuals. Or look, a former client, or a third person, or by the personal interest of you. If you have to do something that's you're doing a tax return for someone, and it's impacting your brother in a negative way, do you have a conflict of interest? What's your relationship with your family, with your brother? You have to think about those things. That's what we mean when we talk about your ethical obligations. As attorneys, we have some ethical exemptions that we are allowed to have, and you'll see those here in the next couple of slides as far as waiver of that interest. Take a look at section B. So notwithstanding, I'm on slide 37 now, notwithstanding the existence of a conflict of interest under paragraph A that we just read, you may represent them if what? If you reasonably believe that you will be able to provide competent and diligent representation to each affected client, if the representation is not prohibited by law, if each client weighs the conflict of interest and gives informed consent confirmed in writing by each affected client at the time the existence of the conflict of interest is known by you. The confirmation may be made within a reasonable period of time after the informed consent, but in no event later than 30 days. Copies of the consents must be retained by you for at least 3 years, 36 months, from the date of the conclusion of the representation of the affected client. And the written consents must be provided to any officer or employee of the IRS on request. So not only do you have to keep these for 3 years, 3 years after the representation stops, which is not necessarily when you file the return. What if the IRS had a question on that return? What if you filed the return on March 15th, and then in July you get a letter from the IRS, and the issue isn't settled until January of the following year? Now 3 years starts. From January of the following year, you have a 3-year statute of limitations to retain the written consent and give it to the IRS upon consent. So you should do that. When you're representing, especially when you're representing an entity, if an individual then comes to you to do their personal return, let's say you're representing a business and it has 4 owners, I deal with small companies all over the U.S. I've got a company right now that I'm working with in Seattle, Washington. They have 4 owners. I'm very limited what I can do. When I go out there and I represent the business, I'm representing the company. I don't care if it's a partnership, company, or trust. I represent the entity. If the individual owners come to me for advice, I have to get a waiver from all of the disinterested parties to make sure they know I've created a conflict of interest. I'm working with one of the shareholders, and they're trying to do something within the company, and I represented the company, the Internal Revenue Service, if the representation involves a conflict of interest. Okay, what's a conflict of interest? I studied this in law school. We live by this rule. We try to live by this rule as attorneys. And here's what it is. It's the representation of a client that will be directly adverse to another client. So please know that if you're representing a partnership and you're preparing returns for a partnership, if their interests are aligned, you can represent both of those parties before the IRS. In other words, you can do both of their tax returns. You can do the tax return for the partnership, and if the individuals want to come to you, you can do the individual tax return. Now, what you cannot do, if there is an adverse interest to them, depending upon how you do that partnership return, the partnership return is being done one way, and you know they've agreed to split profits and losses different than 50-50. But one of the partners is wanting you to do something different on his personal tax return. Now you have a conflict of interest because you're reporting the partnership return as 50-50. And now one of the individuals is telling you, I don't want you to report my profits as 50-50. I only want to report 40 of them. He should be reporting 60. He is a 60% partner, not 50-50. Now you potentially have created a conflict of interest because of your representation of what? The partnership. So when it's one client and it's directly adverse to the other, you have a problem. There is a significant risk that the representation of one or more clients will be materially limited by that practitioner's responsibilities to another client. Same scenario. If you are being limited by your representation of the entity, you've prepared the 1065, and it's limited now to what you can do to the individual. Or look, a former client, or a third person, or by the personal interest of you. If you have to do something you're doing a tax return for someone, and it's impacting your brother in a negative way, do you have a conflict of interest? What's your relationship with your family, with your brother? You have to think about those things. That's what we mean when we talk about your ethical obligations. As attorneys, we have some ethical exemptions that we are allowed to have, and you'll see those here in the next couple of slides as far as waiver of that interest. Take a look at section B. So notwithstanding, I'm on slide 37 now, notwithstanding the existence of a conflict of interest under paragraph A that we just read, you may represent them if what? If you reasonably believe that you will be able to provide competent and diligent representation to each affected client. If the representation is not prohibited by law, if each client waives the conflict of interest and gives informed consent, confirmed in writing by each affected client, at the time the existence of the conflict of interest is known by you. The confirmation may be made within a reasonable period of time after the informed consent, but in no event later than 30 days. And copies of the consents must be retained by you for at least 3 years, 36 months, from the date of the conclusion of the representation of the affected client. And the written consents must be provided to any officer or employee of the IRS on request. So not only do you have to keep these for 3 years, 3 years after the representation stops, which is not necessarily when you file the return. What if the IRS had a question on that return? What if you filed the return on March 15th, and then in July you get a letter from the IRS, and the issue isn't settled until January of the following year? Now 3 years starts. From January of the following year, you have a 3-year statute of limitations to retain the written consent and give it to the IRS upon consent. So you should do that when you're representing, especially when you're representing an entity. If an individual then comes to you to do their personal return, let's say you're representing a business and it has 4 owners. I deal with small companies all over the U.S. I've got a company right now that I'm working with in Seattle, Washington. They have 4 owners. I'm very limited when what I can do. When I go out there and I represent the business, I'm representing the company. I don't care if it's a partnership, company, a trust. I represent the entity. If the individual owners come to me for advice, I have to get a waiver from all of the disinterested parties to make sure they know I've created a conflict of interest. I'm working with one of the shareholders, and they're trying to do something within the company, and I represented the company, and I'm not representing the 3 of you. There's a potential conflict of interest there. But this is how you get around it. The waivers, in writing, consent, held for at least 3 years. And then, and you, again, look at that section B1 right there. You've got to believe you're going to provide competent and diligent representation, and that it's not prohibited by any type of law. So be careful, especially. Now, if you're telling me, oh, Roman, all I do is individual tax returns, and I do them for, that's all I ever do. You still could have conflicts of interest if something you're doing in someone's tax return negatively impacts another tax return. Take a couple that's getting a divorce, and they haven't decided, for one reason or another, they haven't decided on which parent is going to get which deduction for which children. Think about it. Do you have a problem representing both parties? If they're in disagreement, they both want to take deductions for the family. That could potentially create something of that nature. And here's some examples. And we just kind of talked about these. And I'm on slide 38. You represent 2 partners in the same firm. And one partner's positive outcome adversely affects the tax status of the other. That's an example. You represent a business where your sibling is a key employee, and you find evidence of fraudulent activity by your sibling relating to his or her tax status. It's a potential conflict of interest. I have 4 brothers and 1 sister. Of course, they call me to do their tax returns. As far as I know, I've never seen anything fraudulent activity on their behalf, and therefore I haven't experienced that conflict of interest. But be very careful, especially with family members, friends. I represented a company about a year ago, a very, very, very unique part of a tax code that we have that says you can sell a small business in the United States if it was formed during a certain period of time, and it can be tax-free. The seller pays no tax, no matter how much they receive for the business. It has to be a certain type of business. Well, if you have knowledge that there's going to be fraudulent activity in the representation of that transaction, you have to be very careful. And in a situation like that, sometimes there can be, because that tax code is so specific as to when that company was formed and what is allowed for those particular years. You've got to make sure in those situations, if there's any hint of a fraudulent activity, you then have a conflict of interest in terms of representing that business and potentially representing that shareholder if they are a key person. Okay, let's move on. Section 10.3 of Circular 230. And I really hope you did print it or have it in front of you, because you're following right along if you did. And I'm on slide 39. A practitioner may not, with respect to the IRS in any way, use or participate in the use of any form of public communication or private solicitation containing a false, fraudulent, or coercive statement or claim, or a misleading or deceptive statement. You know, it's so funny. I'm on my way today to the studio, I'm driving in to tape the program, and I see a billboard. And I've driven this road for years, and I see a billboard, and it says, injury law, I'm a Harvard grad. Now, that's not false, it's not fraudulent, it's not misleading, it's not deceptive, but you gotta be careful on what you advertise and how you advertise. I happen to be filming this in a state where they're very aggressive with their advertising techniques, and one of the most aggressive states in the country that I've experienced as far as aggressiveness in advertising. But be careful about your advertising, your solicitation. Pay attention to this section. You know, one of the things you're doing, we talked about it about an hour ago, taking this program, that is something different. That is something that sets you apart, that you can advertise. And take a look at the second bullet. Enrolled agents, enrolled retirement plan agents, or federal tax return preparers, in describing their professional designation, may not utilize the term certified or imply that an employer-employee relationship exists with the Internal Revenue Service. I myself promote on our website and on all my marketing materials that I am one of the educational instructors for this program on my tax courses online. And I have to be careful to say, well, it is a program that is produced for the Internal Revenue Service, for tax return preparers across the U.S., not in conjunction with the IRS, not for as an employee of the IRS. We cannot use those designations, but by all means, promote the fact that you are a federal tax return preparer, that you have participated in the annual filing season. Okay, let's take a look at subpart B of section 1031. We get into some more of the ethical requirements that you have as a tax return preparer. And I'm on slide 40, produced for the Internal Revenue Service, for tax return preparers across the U.S., not in conjunction with the IRS, not for as an employee of the IRS. We cannot use those designations, but by all means, promote the fact that you are a federal tax return preparer, that you have participated in the annual filing season. Okay, let's take a look at subpart B of section 1031. We get into some more of the ethical requirements that you have as a tax return preparer. I'm on slide 40. You may not negotiate a taxpayer check. Now, you may not understand what the word negotiate means. What I mean is, when you hear the word negotiation of a check, we are talking about a written check from the Internal Revenue Service, from the government, written out to your client, signed by the IRS. The back of that check is where your client endorses it. It's what's called a negotiable instrument, because in theory, you are allowed to have your client sign the back of the check, and then your client could put pay to the order of Roman A. Basie Tax Service, or my company, the Center for Financial, Legal, and Tax Planning. That is what's called the negotiation of a check. The taxpayer has taken the check, has not cashed it, has not presented it for endorsement to the bank. Instead, has given it to you and negotiated and given it to you, and you've signed it as well. They've negotiated the check with you. You may not endorse or otherwise negotiate the check. And look at what's in parentheses now, including directing or accepting payment by any means, electronic or otherwise, into an account owned or controlled by you or your firm or any entity with whom you're associated. If it's issued to a client by the government, not just the IRS, by the government in respect of federal tax liability. I gave you an example of that. One of you who watched the program this year sent me in a question. Whether or not my fact pattern is identical to yours. If that practitioner accepted that check and they were associated with the person that they were going to negotiate the check to, that would have been a violation of 10.3. I think I pointed the practitioner, and I hope you're listening this year, and I pointed you to Circular 230. And I may or may not have pointed you to this section, but that's the section that's so vitally important. The IRS stepped up section 6694, which is the enforcement of you, the practitioner, because of these factors right there. You know, this whole thing took place when we had the refund loans, which we still have some of this day out there. Not nearly what we used to have. But the refund loans is what caused these sections to become so important. Okay, staying on section 10.31. I'm on slide 41. How about it when a national chain offers a tax refund? In reality, in fine print, these tend to be loans by banks to taxpayers. So even though they think they're getting an anticipated refund, they're really getting a loan from a lending institution. Fine print will most likely say. And therefore, taxpayers must conform at that point to bank requirements. There's probably a credit check ran. Or if they have, there's insurance policies in place. If the tax return preparation company has said, okay, if you have done the return and the client is owed X amount of dollars, we will lend Y amount of dollars based on that return coming in. And that's their guarantee they're going to get paid. And again, we can put it again on this slide. Return preparer does not negotiate these checks, even when it's termed to be an automatic tax refund. Okay, slide 42. Subpart B of section 10.34, standards with respect to tax returns and documents, affidavits, and papers. You cannot sign the tax return prepared from an unreasonable position. I gave you the client example a few minutes ago of the voting situation, and the CPA would not have been allowed to sign that return had they believed the position to be unreasonable. Had a client about 2 years ago, owned a farm, deducted a whole host of things for his farm, was running educational activities out there, had one employee, had a truck for the employee to run the farm, to run the hay bales and all that type of stuff. We signed the return. It was a reasonable position. The IRS audited that tax return, disallowed some of the deductions, and things like the truck were allowed. Some of the educational activities were disallowed. The IRS never deemed it to be an unreasonable position. So make sure, again, I read you the definition of due diligence and the reasonability standards. That's what you're held to. You cannot prepare frivolous documents and affidavits with intentional disregard of tax rules and facts. I deal with brokers across the country, what we call business brokers. I'm sure some of you have been experienced with them. They help buy and sell businesses all over the U.S. You've got to be very careful. They try to create structures to help these deals go through. They want commissions on their transactions. And you've got to watch out for the disregard of the tax rules and facts on those transactions. And what they try to promote to their clientele, it becomes very dangerous for a tax return preparer. And you can run afoul of these ethical rules so quickly. Okay. Section 10.34, standards with respect to tax returns and documents, affidavits, and papers. For example, taking a credit which does not exist. Don't take an expense which does not exist. Get the representation from your taxpayer. What about depreciating non-existent equipment? Most of you will probably get from your clients, oh, John, I bought a forklift this year. Well, it's reasonable to ask for the bill of sale, the bill of lading of the forklift, or title. Forklifts have titles. Ask for a title. Oh, Roman, I bought a new office desk this year. I bought a couch for my office. Hey, it's a big expense. Show me the receipt for that one. Let's see what it was on there for, and let's depreciate it. And let's put it on the books. Don't allow your clients to say, boy, I need another $1,000 in depreciation, or I'm just going to have to pay additional tax that I don't want to pay. Your client says, well, you know what? Let's just add some chairs there. And I can tell you I bought some chairs. Don't do that. Don't depreciate non-existent equipment. You will fail your standards. Hedging your income. Returns not based on records. All standards that you have to follow with respect to these tax returns. You need good records. You need good record books. Okay. 10.35, competence. Note that this section is used to cover what we call covered opinions. The practitioner must possess the necessary competence to engage in practice before the Internal Revenue Service. Competent practice requires the appropriate level of knowledge, skill, thoroughness, and preparation necessary for the matter for which the practitioner is engaged. Do you have the proper knowledge, skill, thoroughness, and preparation? A practitioner may become competent for the matter for which you've been engaged through methods such as consulting with experts in the relevant area, studying the relevant law. This year, as part of the filing season program, we're going over the gift tax return. Have you ever done a gift tax return? Do you understand? If you have to do one this year, maybe you should participate in that part of the program this year if you haven't in the past. And if you don't participate in that, then you should reach out to a professional and say, you know what, I've got a client that's wanting to file a gift tax return. I've never done it. I need to become knowledgeable of the gift tax return and understand what is needed. Oh, I didn't know you had to have a valuation of the gift, or else the statute of limitations does not start. Huh? Those are the things that you might want to become aware of, and by various methods, by consulting with those that have them. And you may ask me questions, and I may tell you, no, I've never done that. I've never had a client take that deduction. There was a big deduction removed this year from our tax returns, the domestic production activities deduction. If you're ever doing an amended return, the producer and I today were discussing the new tax law and how things changed. And I told him, I said, yes, but what's still relevant is the old tax law. Because if you're doing an amended return on 2017, even though you're taking this program, and it's for the next year's filing season, what if you're doing it for a 2017 amended return? What do you need to know? You still need to know. You still need to be competent on 2017 tax law. Well, the domestic production activities deduction's now been eliminated. It wasn't used as much as the IRS wanted it to be used, and they saw it as a deduction. It's on page 1 of 1040, and yet it relates to a business. Competence, knowledge, thoroughness. Reach out, educate yourself, find out what that is. That happens to be one that I am, so you could. Okay, moving on. 10.36. Let's talk about procedures to ensure compliance. Any individual subject to the provisions of this part who has principal authority and responsibility for overseeing a firm's practice, including the provision of advice concerning federal tax matters, and preparation of tax returns, claims for refunds, other documents for submission, must take reasonable steps to ensure that the firm has adequate procedures in effect for all members, associates, and employees. So, if you are an employee of a company, I'll use one of my accountants as an example. I have a wonderful girl, works in the front of our office, does a lot of our accounting work for us, but she is not a principal authority and responsibility. Yes, she assists us with the preparation of the tax return, and she may even sign one or something of that nature. But she is not the principal authority and responsibility for overseeing it. So she does not have the responsibility to ensure that we have the procedures in effect for her. I do. My chief CPA does. Maybe one of my attorneys does. They are the people that have that responsibility to ensure that we are complying as a firm with Section 2 or Circular 230. So if you are a practitioner within a company, take a look at this section. You may not be one that is responsible for it, but you may want to bring this to your boss or your superior's attention and say, you know, do we have adequate procedures in place to know that we're complying with these parts? Just keep that in mind. Okay. Section 10.37, I'm on slide 46. Requirements for written advice. And we've kind of hit on these a little bit. You know, if you rely on the advice of others, you know, if you want to rely on the advice of others, you must still reasonably consider all facts and circumstances. You must use reasonable efforts to identify those facts. You must make sure, again, you're dealing with a competent party. We talked about our standard of review and things of that nature. It's the reasonable practitioner standard. What would a reasonable practitioner say in your circumstance? And then again, if it's a federal tax matter, it's any matter. It's a federal tax matter, and it's required to be in writing under that section. Okay, Let's take a look now. Moving on to section 10.50 under sanctions. The Secretary of the Treasury has the authority to, look at this, to censure, suspend, or disbar a party. I mentioned that right at the beginning. That's why Circular 230 is so important to us. And I don't think a lot of practitioners understand that this is your governing document right here. Because right here is where it grants the Secretary of the Treasury to stop you from practicing. It has the authority to disqualify you. It has the authority to impose monetary penalties. It has the authority to accept a practitioner's consent to sanction. And it has the authority to determine if sanctions should be imposed. That's section